Steve Halbrook, thank you so much for your time, sir. It is great talking with you this morning about this decision by the Supreme Court. So we're proceeding to oral argument on December the 2nd. Now, what exactly does that mean with the court saying be prepared to address the mootness argument when you get here in December?
Well, as I think all the listeners know, New York tried to weasel out of this case several times on the basis that, well, we changed the law. It's no longer adverse to the plaintiffs, and so let's just move on. You can just dismiss this cert grant. And once again, the court decides we're not going to grant your motion to dismiss this on the basis of mootness, meaning that New York argued there's no standing anymore. There's no stake in the case because, hey, they can just take the gun out of their home and go to a home in upstate New York, but they got to get a license there too, of course. But anyway, we've granted all the relief you need, so let's just go home and call it quits. And the court says no. We've said no several times, and we're saying it again. Now, what this does mean is that when the case is argued in December, the parties will argue, first of all, on the behalf of the plaintiffs that the case is not moot. What New York has done is voluntarily ceased unlawful action. They can bring it back when they want to, and of course they filed a brief in the case saying that their previous law was valid. And New York will argue that, well, the case is moot, it's gone away, they're no longer adversely impacted, and, let them eat cake. So, what the court could do, then of course the merits is going to be argued. The merits, like New York went ahead and briefed the prior law and said that, well, it was constitutional. And what I like, the funniest part was this, Heller and McDonald adopted a historical test for whether different regulations are valid. In other words, is the restriction compatible with the text, history, and tradition of the Constitution? And New York said, well, we used to restrict taking guns from the home to go to a shooting range. And then they jumped to the fact that, well, cities have always been able to restrict the shooting of firearms in cities, like think New Year's Eve, shooting guns up in the air in a city. I mean, what a jump. We can say you cannot take your gun to a safe shooting range somewhere because historically there's been restrictions where cities can say you cannot shoot guns up in the air on New Year's Eve. I mean, what a joke.
Yeah, well, it really is, and I'm very curious to actually, see what happens at oral arguments because the city has really declined to try to defend the law. I mean, as you say, they've gone so far as to try to change the law. Now, they haven't said, yeah, we were wrong, it was unconstitutional, but their attempts to defend that statute have been rather half-hearted. Generally, what both sides get an hour for oral arguments, is that correct?
Well, each side will get 30 minutes.
Each side will get 30 minutes. Okay. So, just as a layman, Steve, I got to tell you, that doesn't seem like a lot of time to discuss the mootness and the merits of this case. Is it possible that the court could extend oral arguments, make them longer in December?
That's possible. And in fact, the Roberts Court has done that. I argued cases when Chief Justice Rehnquist was there, and he would never extend time, and he would cut you off right when that red light came on. Justice Roberts has done that. In fact, he did it in the Heller case, and I think maybe the McDonald. And also note that the plaintiffs in this case have agreed that the United States can be heard, I believe, for 10 minutes. So that further cuts them their time. But let me say this as somebody who's arguing cases there. Mm-hmm. You can make your points in 30 minutes. If you have to, you can make them in 20 minutes. You've made them in the briefs already. They've studied the briefs, and they want to turn their attention in oral argument to what they're interested in. Sometimes they argue among themselves. When Justice Breyer starts talking, he uses up your argument time pretty quickly because he goes on and on. But all of that said, if you will be able to make your points, you'll be able to make them on the standing issue and on the merits, and you just have to use your time wisely and conserve your time and use it strategically.
Okay. All right. Now, you mentioned the briefing schedule. We already have seen a round of amicus briefs that have been filed. Will we see another round before the oral arguments? It seemed like, some of those briefs, like the five Democratic senators who wrote their friend of the court brief to the court, basically urging the court not to take the case at all. And that was the tone of a lot of the briefs for the side of New York City. Will there be another round of court briefings before the oral arguments, or was that it?
No, they're done with briefing. And you mentioned Senator Whitehorse's brief. He actually threatened the court that if you don't dismiss this case based on standing, we're going to come after you. We're going to pack the court. And he's talking about in his brief what a disreputable court it is. It's the most unprecedented brief. It should have been stricken from the record. But that said, I mean, you had, when the briefing first started on the merits, you had anti-gun organizations claiming that they didn't really support either side. And then they urged the court to basically nullify any further jurisprudence on the Second Amendment. And then when it came time for the amicus briefs in support of New York to be filed at a later date, although those first ones really supported it, then they all defended the old law and said, oh, this is perfectly reasonable to basically chain the gun to the home and not let anyone take it out. And they're running scared. I have to say, those who don't like the Second Amendment are greatly afraid that the court is going to say something more than just, yes, you can take it out of the home, unloaded, locked up, inaccessible. Because that gets it out of the home. That's what they're afraid of, because the lower courts have been nullifying Heller McDonald. They've been saying, well, you cannot take it out of the home. You can use the gun at the home. That's all the Second Amendment protects, and that's that. So that's why they're running scared. That's why New York was so frantic to get this case dismissed based on mootness. Mm-hmm. And that's got all of these organizations coming out of the woodwork basically saying that the Second Amendment is just, doesn't really mean much, and it's confined to the home. And by the way, if you don't agree with us in the case of Whitehorse's brief, we're going to come after you.
Yeah. Well, over the past, I guess since the McDonald decision, we've seen gun control advocates actually wave the white flag on a couple of cases in order to avoid court scrutiny. There was a case out of the Seventh Circuit Court of Appeals dealing with Illinois' ban on carrying firearms. The state of Illinois lost at the appellate court level, and then rather than risk a loss of the Supreme Court, which would have set nationwide precedent, gun control groups prevailed on lawmakers in Illinois to, okay, go ahead, pass a concealed carry law. We saw in Washington, D.C., their quote-unquote good cause a requirement for concealed carry struck down by the Court of Appeals for the D.C. Circuit. Gun control advocates, again, convinced local politicians, don't appeal that up to the Supreme Court. We don't want that national loss. So they've been running scared from their own gun control laws and court scrutiny for darn close to a decade, Steve.
That's right. And of course they were frightened with the idea that all of those circuit decisions would be overturned and there would be some kind of entitlement to carry outside the home based on not simply a discretionary license issuance regime. But here you got just a little baby step. The city of New York said you can't even take it out of your home for any reason. You got to keep it there, and there's no right to bear arms. And if a police official files an affidavit saying it would endanger public safety to let you take it out of the home, by cracky, that's good enough for court. And so here you have the Roberts Court trying to take just a little baby step, and they're going frantic. They're afraid of that. And once again, once you get the gun out of the home, it means that, okay, if there's a right to transport it from my home to some other lawful place, maybe there's something more after that. Maybe, hey, look at the text. Guess what it says, the right to bear arms, not just the right to keep arms. So that's what they're afraid of, that the literal wording of the Second Amendment might be actually recognized by the Supreme Court.
Well, honestly, it already has been in a way. In the Heller decision itself, the court, went through the Second Amendment basically word by word and defined what those words mean. So the Supreme Court has talked about what bearing arms mean, and it absolutely means, according to the Supreme Court, carrying firearms outside of the home. Now, this isn't, as you note, a carry case. This is a case dealing with transportation. So why are the gun control advocates so freaked out about this little law, Steve? Is it because of how the Second Circuit Court of Appeals reached its decision, saying that under intermediate scrutiny, this law and virtually every other gun control law in the books could be upheld? Is that what gun control advocates are really worried about, that the court could revisit that standard of review that's being used by so many appellate courts?
Right, misused, not used, and it's all about the methodology in which you interpret constitutional rights. Some courts have said, "Oh yeah, we read Heller, and it does say the right to bear arms and the individual right to carry arms, and it's outside the home. But if we apply intermediate scrutiny, we do basically the Breyer balancing test from his Heller dissent. And yeah, it's a constitutional right, but it's overcome because it endangers public safety. You've got the governmental interest. It overrides the constitutional right, so you can basically ban it. And also, there's something else going on here. There's normal rules about procedure in court, where if you ask the judge to render a decision on your side based on declarations, affidavits, instead of going to trial, it's called summary judgment. And here you had the mere filing of an affidavit by a New York City police official saying that exercise of this right would endanger public safety, and that was good enough for the court. You got not only the idea of intermediate scrutiny, which the court should say does not apply in Second Amendment cases. They should say, we look at text history and tradition, and under that, there's certainly a right to carry. States might regulate how you carry openly versus concealed, for example, but you've got to recognize the right. And then the other issue is even more basic than that, like basic summary judgment. If you file affidavits on both sides, and if there's any question at all about whether one side doesn't get judgment as a matter of law, you go to trial. You deny their motion for summary judgment, yet we've seen in case after case, the courts just, they look at what's been presented on the papers. They don't go to trial. They look at the fact that, well, the governmental entity said that this would be a danger, so we're going to say that the law is upheld, and heck with it, what the Constitution says.
Mm-hmm.
It's a question of methodology, a question of scrutiny. I mean, strict scrutiny normally applies in constitutional law cases where if you want to restrict the constitutional right, it's going to be a compelling government interest. It has to be the least restrictive way of restricting the right. And you still have to allow the right, by the way. And here, of course, they simply banned the right to bear arms in these states. I don't know, what is it, 8 states that have laws of that type and all other types under the sun, restricting an amendment. And so, yes, it's a question of methodology. It's how the courts interpret rights, because that's how they've gotten away with murder after Heller and McDonald. They say, yeah, it's a right, but they explain it away.
Yeah. All right. Last thing we'll ask you to explain for us. Oral arguments December the 2nd, but we won't get a decision in December. When do you think the court will actually issue its opinion in New York State Rifle and Pistol Association versus New York City?
Well, if this was a right-out carry case, I would say it'd be the last day of the session in June in the year 2020. But the court might issue a decision before that. If you remember the Catano stun gun case from Massachusetts, that was 8-0. Justice Scalia had died at that point. That's why it wasn't 9-0. And the court said, we don't agree with this Massachusetts ban on stun guns, and we're going to send the case back. I mean, this case, there'd be no reason to remand the New York case back to the state court or the Court of Appeals, rather. But it's conceivable that there could be a decision earlier than that. I mean, would every single one of the justices who basically votes against the Second Amendment otherwise, but didn't do so in Catano, you might actually get a majority, and they might actually agree on a decision in this case without having to extend it till the end of June.
Wow. So you think there's a possibility that we'll see something other than a 5-4 decision in this case?
Possibly. But based on the fact that we've got established precedent, we've got such a flimsy basis to say that you can't take it out of the home. And you had the justices in Catano, all of them, agreeing that that case should be remanded. I mean, had they believed that you could never have any kind of weapon outside the home in Catano, they could have just said, they could have just denied review of the case, because Ms. Catano was caught in a parking lot with the stun gun. So, why would they even say that you violated our precedent in Heller to remand the case back to the lower court, based on the fact that the court didn't conduct the kind of review that Heller said you had to conduct about the type of arm? Because they said, well, a stun gun, they didn't exist in 1791 when the Second Amendment was adopted, and they gave some other frivolous reasons that were completely contrary to Heller. I mean, Heller said that just like the First Amendment, modern ways of doing things are protected under the Second Amendment as well.
Exactly. Steve Halbrook, Second Amendment attorney and scholar. As always, sir, it is great talking with you today. Thank you for spending some time with us.
Yes, sir, Cam. You too.
Look forward to doing this again very soon. Steve Halbrook with us here on Bearing Arms Cam and Company.